Hello, Alison. How are you?
I'm living the dream. How are you?
I'm fine. I know you're living the dream. I keep following you and reading everything you're doing. I'm always smiling and laughing when I read your comments on social media. So it's just for everyone who's watching, Alison Craig is really the one to follow on social media. So she's really very funny. And also, you also give us a lot of information about the law. And this is actually what you're going to be doing today in a very specific area of the law that you have a lot of experience in. You do a lot of sex assault cases and you're good at them. And this is an area that is becoming more and more challenging for a lot of defense lawyers to the point that some lawyers don't even want to take on these cases because of how
Yeah,
complex they are.
exactly.
Just to help, we decided that it's worth it to make a series on sex assault cases, and we see Allison's family.
Pardon the kittens.
so um, so we're going to be doing a series on sex assault cases, and this is the first episode. And the focus of this one is going to be on the pre-trial motions in sex assault cases. So let's start then, Allison, by let's say the first question, which is what are the types of pre-trial applications that we find in these types of cases?
So the very basic ones are obviously 276 and 278. 276 with respect to any questions or information that you want to adduce about prior sexual activity of the complainant. And then 278, nobody really knows what it means anymore, but for records that you want to adduce, essentially. Those are the two main types.
All right. And so the other question that is also very important to know and to ask in these types of cases is, should we bring these applications or not? And this is a really tough question because of the information that could be revealed, especially when it's the records and especially when it's on the defense side. How much do you want to reveal from your case? So let's get into that. Should we bring these applications? If so, when?
Oh gosh, it's such a complicated question because you're right. Now that there's essentially this reverse disclosure obligation on
Mhm.
the defense, it really is a tough strategic decision to decide whether you bring it in advance or not. And obviously, every case is different. If there's, an obvious basis to bring it ahead of time, that I think you have to. For example, let's say the complainant provides some text messages to the Crown or to the police, and your client has the rest of the conversation that is clearly gives it a lot more context or shows that the complainant was being misleading or whatever. Then I think you have to bring it ahead of time because there's no way to possibly say you didn't anticipate the necessity of doing it, right? But I really try not to. And I
Mhm.
try and do it sort of mid-trial, and say, well, I didn't anticipate that this is going to be an issue because I really want to avoid the reverse disclosure.
Right.
So it's kind of I don't know if it's a bit dishonest or just disingenuous, but
No,
you
it's a
know,
strategic
it's
decision,
a
I
strategic
guess. Yeah.
decision, exactly. And if you're going to get you know what from the judge, so be it. You'll take the you know what from the judge
Right.
if it helps your client, right? So often, if I have records, text messages, or whatever, um, and there's nothing obvious in the complainant's statement that they would be directly relevant to, I don't bring an application. And then I ask questions during the trial that I know will somehow make it relevant. And then I didn't anticipate this was going to come up. I didn't
Mhm.
anticipate her answers. She didn't talk about this in her statement, whatever. And then I can bring a mid-trial 278. And usually it's allowed. Sometimes you get a little flack from the judge, but so be it. It's the client's interests that are most important.
I mean, it seems like the courts are showing some kind of irritation towards the mid-trial applications. And it seems even from the Supreme Court, like with JJ and all these decisions, that they would rather have these applications brought before trial. But obviously, I mean, from a defense perspective, it's always like you want to leave and save whatever you have until the very, like closer to the cross.
Exactly. It's
Yeah.
a difficult decision. but there, I mean, obviously there are cases where you have to comply with doing it ahead of time.
Yeah.
There's
Yeah.
simply no way that you could argue to a judge that you didn't anticipate it being relevant somehow. But if you can creatively delay it, I would encourage it because I do worry about obviously the Crown providing things to the complainant ahead of time. She'll have counsel, she'll get notice, and then you're sort of giving away your defense, which
Right.
I really, really hate. So I try and avoid it whenever possible.
And I mean, obviously, the other issue here is that this is something that we only do in sex assault cases. Whereas if this was a domestic violence case and we're not talking about any kind of sexual context, we don't have to provide anything in advance, not to the Crown,
Exactly.
not to the court. But what about the prior sexual activity, though? Is it the same thinking that goes into the
Yeah.
analysis?
Yeah.
Yeah.
For me, it is. I mean, um, there's obviously, I'm less worried about the prior sexual activity. That
Hmm.
has always been something that you've had to bring a pretrial motion
Yeah.
for. I've never really found it to be detrimental to my case. So that's a little trickier to save. I think if you're in any way, shape, or form going to be crossing that line, I think it's best just to bring it as a pretrial motion. And I've never had any issues. So 276 is always in advance. And I mean, things are going to arise during a trial. You can bring it
Yeah.
mid-trial, but generally speaking, you know ahead of time, well ahead of time, that it's going to be somehow relevant to your defense, whether it's, the one I seem to find all the time is safe words. My clients, I've had so many cases where they tell me that they had this safe word that they always had with their partner when it's,
Hmm.
a friend or whatever. Um, and so I've always brought that in advance. There's no way I could argue to a judge that I wasn't
Yeah.
expecting it to be relevant. So 276 is I generally always bring in advance. 278, I try at all costs to figure out a way to bring it.
Yeah. Yeah. And there is still, you think, a strategic advantage to delay it as much as possible,
I
despite,
do.
like, and I agree with you. I wasn't very happy when I was reading in JJ that they should be brought in advance.
Yeah.
There is obviously, from a defense perspective, a tactical advantage in delaying those applications. Okay.
Yeah,
So,
exactly. And the other thing I would say is, I mean, the, the system brought this on itself, honestly, because and I go on this rant all the time, but when they got rid of preliminary hearings for sexual assault, I think the idea was it was supposed to shorten the proceedings, make it less onerous on the complainant, all that sort of stuff. However, the problem is preliminary hearings were always what we used to determine, for example, what records applications we needed to bring. You could, ask questions and figure out if you needed to get medical records,
right.
what text messages might be relevant, and all that sort of stuff. You can't do that anymore.
Yeah.
So I almost every sexual assault trial I do these days seems to go off the rails, not for the strategic reasons I've been talking about earlier, but I ask, well, have you ever talked to a counselor about this? Well, yes, I have. There goes that, right? You
Yeah.
need to stop the trial and bring an application to get records and that sort of stuff. So in many ways, the system brought this on itself. Not that you'll get much sympathy with the judge when you explain yourself that way, but
Yeah.
that there was a big, big problem when they got rid of preliminary hearings for this.
Right. And that's for all cases, to be honest. Like for
Yes.
different types of cases, a prelim served a different type of purpose. And it's
Yeah.
unfortunate. And quite frankly, I don't think the problem of delays has been solved by eliminating preliminary inquiries. It seems, if anything, that it's worse
Correct.
right now.
Yes, it is because, and for sexual assaults in particular,
Yeah.
because your trial blows up mid-trial. You have to get continuation dates for the applications in front of that one particular judge, and then trial continuations in front of that one particular judge, and it becomes a nightmare. It takes way longer than it ever would have
Yeah.
most of the time if you'd had a preliminary hearing.
Well, and to add to that, we recently also had a decision from the Supreme Court, the Kinamore decision, which is also on the Crowns now, who also
Yes,
need to bring applications. So that's also going to lengthen. So that's also a pretrial application that the
it
Crown
is.
has to bring,
Yes,
but that our clients are forced now to attend as well, right?
yes,
So,
yes, exactly. So yet another step that just adds more and more delay to each sexual assault case.
And those are applications that the Crowns now have to bring for the materials that they intend to use at
Exactly.
trial.
Yeah, it's basically like a Crown 276.
Right.
Yeah.
Okay, so let's get then into the specifics more of the 276 and 278. How do we argue them? What are their tests and who brings them and all of that? Let's start with 276, Alison.
Oh gosh. I mean, 276, well, I was going to say it's always the defense. Now it's not always the defense,
Yeah.
but Crowns can figure themselves out. They
Yeah.
essentially, yeah, they have to, if they want to explore that, they have to get permission from the judge as well ahead of time. But a 276, yeah, you have to show it can't just be a fishing expedition. You have to show that it has particular relevance to whatever the issue is at your trial.
Mhm.
And again, going back to the example of safe words, that's the one for whatever reason, maybe it's a weird niche practice I have, but that's the one that I seem to come across all the time. So, a client will say to me, yes, whatever sexual contact happened, but we have a safe word and it's, toilet, whatever. And she didn't say it, and so, on and on and on. So I have to bring an application and I have to lay all of that out in an affidavit from my client and explain to the judge why I should have to ask the complainant about her prior relationship sexually with my client because his defense is she didn't say the safe word, or at least part of his defense is she didn't say the safe
Yeah.
word. How can I adduce that without asking her about it previously? And so that's why it's likely relevant. So um, that's the test
For the 276.
for the 276. Yeah.
And so, and timing wise, when are these applications brought?
Well, they're always brought ahead of time. Every court jurisdiction seems to have different rules about, I don't know about rules, but different sort of protocols for when they
Yeah.
schedule these. But they're always done well in advance
Yeah.
because there's um, two stages, although sometimes they do them all on the same day. The complainant is entitled to counsel. That takes a while to arrange on behalf of the Crown. You have to file detailed material. So it's always well in advance of the trial, certainly a couple of months or sometimes more.
Yeah. It's around like 60 days in advance that
Yeah, and
we
I've
usually
had
see.
them, there's some jurisdiction I was in recently, they said they always did them 4+ months in advance.
Okay.
So sometimes they're even more than that. But yeah, at the very least 2 months or more.
Yeah.
Yeah.
Okay. And right. And then what about the 278?
Same thing. It's two stages. It's always done well in advance of the trial. If you're bringing it pre-trial, which again, I try and avoid in a lot of situations, but it's always done well in advance of the trial. Same as the
Mhm.
276.
And the 278, though, here, just to clarify, this is when we're bringing them for records that the
Exactly. 278
defense.
is a records application.
And so the difficulty here that sometimes the defense will face is really proving the relevance of the records that we want to use. So if we could just talk a little bit more about that in depth, because that's the hardest part in a 278.
Yes, it is. And you basically have to lay your whole defense out on the.
Yeah.
I mean, some of them are pretty obvious. Like, for example, a text message conversation. I've had a couple where the complainant had texted or emailed or Snapchatted or whatever, a friend saying, giving like a totally different version of events, something like that. And then that comes into my possession. Obviously, that's relevant, right? It goes
Hmm.
directly to her credibility. Um, Medical records are almost always you at least pass the stage one, and then the judge will look at them and determine what you can see and what you can't. But those are almost always relevant. If the complainant is talking about the event to her doctor and she describes different injuries or she describes a different version of events, those are almost always relevant. And I find things that just go directly, there's a lot of argument in the law about, well, if it's just going to credibility, is it really relevant? Does it have to be relevant to another issue at trial? I've seen that debate many times. I almost always get them in if it's just going directly to the complainant's credibility.
Okay. And so to clarify here, the stage one and stage two, if we can just briefly explain what they
Stage
entail.
Yeah, so stage one of the 278 is like the threshold
Hmm.
stage, where you make your arguments, you convince the judge that they may be relevant. The judge then reviews them if we're talking about, medical records,
Hmm.
psychiatric records, whatever, then decides what you can see and what you can't if you've passed stage one, provides them. And then stage two is arguing whether or not they should be admissible at trial. So whether or not they're likely relevant at trial. Um, and the complainant gets counsel is the other important thing to remember.
At the stage two.
Yes,
At the
exactly.
stage
So
two.
you're not just dealing with the Crown, although usually they're ad idem on their arguments, not always,
Yeah.
but yeah, there's another lawyer involved.
And also, I think one thing that's important to clarify is that these are happening, um, like these are in camera
Yes,
proceedings.
yes,
It's not open court.
exactly.
And so even when it's happening by Zoom, you'll get also your judge who will give you the warning that you make sure that nobody's around because this is
Yes,
not open court
exactly.
for these proceedings. Now, now here's the bigger problem that we can have. So let's say you're the defense and you bring this application and you have to show these materials so that the judge can make a decision as to whether or not the judge is going to allow these materials or these records or
Yeah.
until they are decided to be records. Um, and let's say the judge decides, okay, no, I'm not going to let you use them. So then what happens? Like it seems like the defense now is in a very difficult situation because the complainant knows where the defense is going, but you
Mhm.
can't use that. So how can you save yourself when you're in that situation?
You can plan for an appeal.
Yeah.
I mean, you can, eh, often the judge will, at least in my experience, that they'll say the foundation isn't there yet, or they'll explain why the foundation isn't sufficient to make it likely relevant. So you try again mid-trial often, right? I've done that a few times, and the judge has said to me a few times on a 278, look, Ms. Craig, you're welcome to ask her insert more generic question here related to the records. If she denies it, this is usually about text messages, for
Hmm.
example. If she denies it, you're welcome to renew your application, right? So, for example, a text conversation where just on its face, the judge says this doesn't meet the test for 278. I then ask the complainant during cross-examination, did you guys talk about whatever the content of the text message conversation is? If she denies it, you renew the application. So oftentimes they can be renewed if more of a foundation for the application can be built up mid-trial. Um, but otherwise, I'm being serious when I say plan for the appeal. And,
Yeah.
sort of, um, I would try. I would try to sort of lay more of a foundation in your cross-examination of the complainant, sort of painting the picture of why this would have been so relevant and maybe express a little frustration, dramatic pauses, you know what I mean, during it when obviously this is when you would have raised it. Um, so try and sort of lay the foundation for your appeal during your cross.
All right. Um, I mean, if, for example, the judge, but the issue sometimes that we have here is it's how to deal with the judge on these types of applications because we're finding judges are becoming very much um, well, not defending, but there's a lot of pushback. There's a lot of resistance
Oh
to the
yeah.
defense to bring these applications. And I find
Yeah.
like on top of the law itself being difficult to deal with, we have also these judges who we feel are not always very understanding and they keep
Mhm.
asking like why and you have to explain and give more information. So if we can also just give some tips on how to deal with judges in particular in these types of cases because they are getting the sense is sometimes a bit more difficult in a
They
sex
are.
assault case as opposed to any other type of case.
Yeah, they are because the Supreme Court just case
Yeah.
after case after case in favor of the Crown. So, no wonder they don't want to be appealed. And
Yeah.
it is a messy area of the law, but don't back down. I mean, make
Yeah.
it clear how detrimental to your defense it's going to be if you can't lead whatever the record is. So, I mean, honestly, the best advice is just don't back down. You always have to, we always want to win trials, right? But you also always have to protect the record. So, for future proceedings, appeals or otherwise. So, um, really sit down. Like these are worth preparing for, right? Not just off the
Yeah.
cuff, file the materials and sort of make submissions on your feet. Really sit down and think it through and make a whole list of reasons why it's relevant and what could possibly be different about your defense if you're not allowed to adduce it. I think the devil really is in the details a lot of the time
Hmm.
with these applications. Don't just be a generic, it's
Yeah.
relevant to her credibility or whatever. Be very, very detailed and point to like specific examples from her statement that it might be relevant to, or specific examples from your client's anticipated evidence that make it so necessary. So I think the best advice, number one, is don't back down, but number two, the devil is in the details. Be specific about what these records go to rather than just generic.
And also, maybe something that defense lawyers should be mindful of is that it's not because your client gives you information that you necessarily have to use that at the trial. You don't
Oh
have to
no.
use everything. So you have to really, I think,
Yeah.
like what you're getting at as well is you have to really filter within what you have, what your client gives you, what is really necessary
Yes.
for the defense, and not just, well, I have them and I would like to ask questions, but they're at the end of the day, they don't really like the defense doesn't turn on these materials.
Exactly. Pick your battles for
Yeah,
sure. I do find, for whatever reason, I guess domestic and sexual assaults are the two most common.
yeah,
The amount of nonsense that the clients
right.
you, like volumes and volumes of emails and messages that have nothing to do with anything and all that sort of stuff. And they do tend, and I don't know why it is, but they do tend to be very particular when they're saying, ask her this, ask her
Yeah.
that, show her this picture, show her that. I don't know why it is, but most of the time it's absolutely irrelevant. So, yeah, I mean, the best lawyers are the ones that walk into court focused on the issue and filter out all the nonsense, admit all the other things. Don't get distracted by your client's, photo book of 2,000 pictures he wants shown to the domestic complainant and or sexual assault complainant. So, yeah, be focused. Most
But
of what your client sends you is not helpful.
exactly. And but here, I mean, you do like this leads to an important point now that you're making, which is, well, how do you deal with the client who, because sometimes it is the client who tells you, well, no, I want you to ask questions about that or about, this,
Yeah.
that she liked someone, but it has no relevance whatsoever to the case. The fact that she was seeing someone else, like it has really no relevance sometimes. And yet the client insists, like, this is real, that's really what they want you to be asking about more than the actual criminal offense.
Yeah.
So, how do you deal with the client here? Because that can also be a challenge.
It can be for sure. Same answer as the judge. Don't back down. Like
Hmm. Right.
it's our job not just to take instructions from the clients, but to teach them, educate them, give them advice. And I always explain to clients what I just said, which is that, look, I know how to win these cases. And the way you do that is to walk into court focused, head up high, get to the point. The judges love you. What I find really gets clients to listen is when you explain what the judge will hate,
Hmm.
right? If you take up all of this time, judges don't like people who waste their time. Judges like it when you're focused and get to the point, and it's far more effective. So I usually, rather than just explaining like, don't just sit down and be a legal scholar or professor. They don't, if you just sit down there and sort of explain case law about 278 or 276 to them, they're not, it's going to go right over their heads.
Yeah.
Um, so speak in practical, straightforward, common language and just say, look, if we adduce all this stuff, you're going to piss off the judge. And this is why.
And
If
you
we
will lose if you piss off
Exactly.
the judge.
Correct. Yeah. So don't. don't pull out your book of case law and start telling them about all the Supreme
Yeah.
Court jurisprudence. That means nothing to them.
Yeah.
Speak in plain language, and they're far more likely to understand what you're saying. I don't ever have that issue anymore. I you know, throwing in the odd F-bomb also helps too, which I
Yeah.
do more often than I should. But I find once I really started, I threw my criminal code in the corner and started just really explaining things in practical, plain language. Clients really started listening, and I rarely have that issue anymore.
All right. So let's talk a little bit, though, now, Alison, about the complainant's role in all of that, because she does have standing, which is very unique. We don't see that in other types of criminal cases. But let's talk a little bit about the complainant, their role, and how much they can have an impact on this whole process.
Yeah, I mean, you're right. It's the only time a complainant ever gets counsel. And the counsel that, like, there's a pretty small sort of bar, I think, of complainants counsel that do most of these cases.
Yeah.
So they really know what they're talking about. So be prepared because they do get to come in and argue against your application and say why this isn't relevant, why
They
it's
can provide
prejudicial.
materials as
Oh,
well. Yeah.
yes. Yeah, they could provide materials. They'll provide, I guarantee, a fulsome factum. Um, and they're usually very, very effective because they know the law like the back of their hands because this is all they do for the most part or a large part of what they do. So um, they will argue very
And
effectively.
unlike the crowns, they represent the complainant. So they
Exactly.
get to talk to her about the specifics of the case because crowns are not allowed to get into the details of the case
Exactly.
with them. So they will know a lot of information that the defense know.
Yes,
So,
exactly. They will. And you don't they don't really have the same, like our clients, we have to generally provide, a fulsome affidavit from our clients explaining this, that, and the other thing. That they don't have to
yeah.
do that. So you're you're sort of at a disadvantage from that point. But yeah, you're going to be facing a very skilled lawyer who will know every case about this like the back of their hands and often be able to convince the judge that this is nothing but a fishing expedition and shouldn't be allowed. So do your homework, be prepared, write a factum, find specific cases, not just the general ones that we all know, but specific cases about specific issue or the specific record, because complainants counsel will. Um, and they will always argue that it's I shouldn't say always, that's not fair. Occasionally they concede these things, but for the most part, they will argue that it's highly prejudicial.
All right. And on the records, I know you did mention some of them, but usually, and I know it's not very clear in the law what these records are, but if we just want to, I mean, we know that text messages for sure.
Yes.
Um, I think there's no issue, and that's what we commonly see. But
Yeah.
what could these records also be other than text messages?
It does seem to change by the day
Yeah.
what is defined as a record and what isn't. So, ask me tomorrow, my answer might be different. But
Yeah.
yeah, text messages or any social media, oh, I shouldn't say that, private social media messages. Um, I find, a lot of private DMs now more than just plain old text messages that us old people use. Counseling records, medical records, I think those are probably the other most common kind. Those are the ones because you'll get like if a complainant, for example, goes for a sexual assault kit at the hospital, that's
Mhm.
part of standard disclosure. You'll almost always
Yeah.
get. But there's often other medical records, um, and definitely counseling records. When you're dealing with younger complainants, CAS records I find often come up. I think those are the most common ones. Definitely text
Journals
messages,
sometimes.
journals,
Yeah.
yes. If people still do that, I've had a couple journal
Yeah.
cases for sure. Um, I mean, there's less of that now because these days it tends to be more like blogs or things that are
Yeah.
out in public, and so there's
Yeah.
not really the privacy interest anymore. But medical records and text messages for sure. Those are going to be the most common ones.
And honest, and I think like one wise thing also to tell our clients is to stop creating more of that, these messages, because text messages are becoming really weapons
Oh
against
yeah.
our clients.
Oh
So
yeah. Big time. Stay off the phone.
yeah.
Stop apologizing on text message. Stop. This isn't a sexual assault thing, but I recently had a homicide case where the dude was like live texting the whole thing. Tell your clients to stay the bleep off the phone.
Yeah.
Yeah.
I mean, that's the thing. Um, Another, and again, like just before we end for this episode, Alison, one of the other issues that we have is when the clients, they know that they had an answer that is in their favor, but unfortunately, what we see with a lot of clients is that they either delete their messages, so they
Mhm.
don't have the relevant part that they're referring to, or because they were blocked, they don't have access
Mm.
to the messages.
Yeah.
So, how do you deal with these types of situations when there's something that you want to use and it's no longer with the client, um, and you know, like the complainant may have it?
Right. Practically speak, so there's a couple of different ways. As a technical issue, I've actually been able to get a tax expert to look at
Retrieve?
the
Yeah,
device and retrieve the
yeah,
messages on a few occasions. Sometimes they can, sometimes they can't, but that
yeah.
is not impossible. Um, during, and again, this is something that tends to throw the trial off the rails, but many times during the trial, I've asked the complainant and gotten her to agree that there might be more to the conversation or what have you. And I say, would you be willing to provide it to the officer in charge tonight? Go home, get it, give it to us. If they say no, great, huge win for you. And
Mhm.
if they say yes, and your client is right, I mean, make sure they're right about what
Right.
they're telling you before
Yeah,
you choose this route. But it's a win-win, right? If they refuse to do whatever, or they admit that they didn't provide the officer in charge with the full conversation, that tends to weigh pretty heavily against their credibility. And if they agree to go home and find some more things and with their tail between their legs, come back the next day and give more of the conversation that supports what your client said, also a win.
yeah.
But make sure you're confident that what your client, like I scream and yell and say, I'm getting off the case immediately if you're wrong here. But not that I
But
really
that
would,
is
but that's what I tell
actually,
them.
but that is a problem with many
Yes,
clients, is that they will insist on something, but then when you look at it, it's not really what they're saying.
exactly.
And then it puts the lawyer in a difficult situation
It
because
very much does. Yeah,
yeah,
I threaten to get, I always will tell them, if you're lying to me, I'm getting off the record and you're
yeah,
finishing this trial yourself. Can I ethically actually do that? I don't know. I've never actually had to, but that's how I threaten them.
yeah,
And sometimes they say, okay, maybe don't, maybe don't.
yeah, yeah,
So yeah, you've got to just make sure that you're clear how badly this could go if they're not telling you the full truth.
right.
Yeah.
So, Alison, what else do you have to say about these pretrial applications in sex assault cases?
I hate everything about
Yeah,
them.
but you
Uh,
do so many of them.
I do. I do. Oh God, it just drives me crazy how much of an onus is put on the defense in all of these things now. But um these are I'm often, I shouldn't say often, that's not fair. I'm not always the best at sitting down with my clients for most kinds of charges and getting a second by second, like really detailed interview early on. I tend to be someone, unless the case screams at me to do it early, that I read the disclosure, I set trial dates, and then we really get into the
Yeah,
nitty-gritty. Sexual assaults, I think it's important to start planning strategy and motions early on. Like really sit down with your client and get every detail that you possibly can from them. What records might we want to pursue? Are they records we can get some other way with a private investigator or whatever? That sort of thing. And this isn't so much in pretrial motions, but the earlier you start, for example, if you want to hire a private investigator, that sort of thing, you want to start working on that sort of stuff early on. So really, even though pretrial motions are going to be months and months, if not more, down the line, I think when you're dealing with a sexual assault, you really want to get down to the details with your client early because there's a lot of work ahead of you.
Yes. And I mean, if there's one advantage, though, to the pretrial motions being way ahead of time, is that at least it gives you some time to
Yeah,
readjust your defense and maybe consider if you should proceed to trial, because sometimes it's so damaging that you might want to reconsider
yeah,
how you want to proceed in this
agreed.
case.
Yeah,
Mm.
agreed. Although I have only in my whole career ever done one guilty plea to a sexual assault
Yeah.
in
Oh
20
no,
years.
I think most
Yeah,
clients will want to proceed, even if it's summarily. I mean, they're so
yeah,
serious that even when they're on the lighter side and the Crown is proceeding summarily, clients will still want to have a trial on
yeah,
these types of cases.
yeah, always.
So, all right. So this covers here today the pretrial motion. So we will continue with more about sex assault cases. But thank you so much, Alison. That was really very like I've learned a lot from chatting with you today, and I'm sure that anyone who's watching this is going to learn so much. So thank you so much for your time.
My pleasure. I think the kittens learned a thing or
Yeah,
two. They're tuckered out and now they're asleep.
I'm sure they did. Thank you.